Your Worships, I have had a call put out for the next case, which is a private law case on your list, Grover and Grover. Both litigants are in person, but I understand the applicant, Mr. Grover, is bringing Mackenzie Friend with him today to assist him.
Is this Court 14?
Yes, it is. Are you Jane Grover? Do come in. Please sit yourself on that side of the court.
Good afternoon, Miss Grover. We're just waiting for Mr. Grover to join us. Are we aware if the applicant has signed in?
I believe he has, ma'am. Should we give him a few minutes?
Yes, but as I understand it, we do have another case listed.
Yes, we do, ma'am. So we may need to make a decision sooner than later about... Mr. Grover?
Yeah.
And who is that with you?
I'm John Whitfield. I'm Mr. Grover's Mackenzie Friend.
Please excuse me for interrupting you, Mr. Whitfield. But if you are here as a Mackenzie Friend, then we would need to seek some guidance from our learned legal advisor because, as I understand it, you do not have the right to audience in these courts. Madam Legal Advisor?
Yes, ma'am. Perhaps if I were to begin recording and introduce the case to you. This case is WFC 44921743 and is a case management hearing concerning Mr. Jason Grover, who is making an application for contact with his son Nathan, who is aged 6. The respondent is Miss Jane Grover. Both are litigants in person. However, today Mr. Grover seeks permission to be assisted by a Mackenzie Friend. I can advise your worships that practice guidance of 2010 states that Mr. Grover can exercise the right to reasonable assistance from a layperson, sometimes called a Mackenzie Friend. This means, Mr. Grover, what your Mackenzie Friend, Mr.
Whitfield.
Thank you. Mr. Whitfield may do is to provide you with moral support and take notes, help you with certain aspects of the court proceedings. What Mr. Whitfield may not do is to act as an agent for you in today's proceedings. For example, signing court documents, or making oral submissions, or interviewing witnesses. Miss Grover, do you have any objections to Mr. Whitfield acting as a Mackenzie Friend to Mr. Grover?
No, it's fine.
Thank you, Miss Grover. Your Worships, it is at your discretion if you allow permission for Mr. Grover to have a Mackenzie Friend acting for him today.
Yes, we have no objections to Mr. Whitfield acting as Mackenzie Friend to Mr. Grover, provided they both understand the limits of what may or may not be done in that role.
Yeah.
Given that both parties are litigants in person, I think it may be helpful to say what we mean by a case management hearing. This is a short hearing to sort out any practical matters to get the case ready for the full hearing so that a decision may be made. The court might make directions setting a date for you to submit evidence, for example. We will hear from both of you in turn today. I will ask both of you not to interrupt each other. So if you want to say something, note it down and you will be given an opportunity to say that later. The magistrates will decide what evidence the court may need, and we will set out a timetable for that evidence and a further date for you both to return to court. Do either of you have any questions about what to expect today?
No.
That being so, your Worships, perhaps we can hear from the applicant, Mr. Grover, as to why he's making this application for contact with his son.
Yes, thank you. Mr. Grover, what do you want to tell us?
Well, I just want to see our Nathan. You know, we split up about 2 years ago, and it was fine at first. I was getting to see Nathan regular, like every other weekend and for tea in the week. That worked. That was fine. Yeah, I mean, there was some times when I couldn't make it because of work, but I could usually see him from school. But then she started saying that Nathan weren't well and that he couldn't come. And, well, I understood all that, but it just started happening more regular. So I was only getting to see him, twice a month? if that. I tried talking to her, but she wouldn't listen. She just kept saying I weren't a good father and she weren't happy with where I was taking him. So she stopped Nathan from coming back to mine. I asked her if he could stay over on a Saturday, but she said no because he was too young. Yeah, she also didn't like it when my mum would see Nathan. Doesn't trust it. You see, that they had an argument last year and they don't speak to each other now. Yeah, and then in January, she saw on Facebook that I've been seeing Alison. Alison's my new girlfriend. She sometimes stays at mine. And she said that she didn't know who Alison was and that she didn't want a stranger looking after her son. So after all that, she just stopped me from seeing Nathan altogether. I haven't seen him since the end of January. I tried talking to her, but she won't answer the phone to me. She'll just text me saying she doesn't want Nathan to see me. Look, I know that we don't get on, but it isn't about that. I just want to see Nathan and he wants to see me.
Thank you for that, Mr. Grover. Can you tell the court what sort and how much contact you would want with Nathan?
I just want to see him more regular, like, so ideally I'd like it to go back to the way that it was, so every other Saturday and once in the week. I think he's old enough that he could stay over and then in time every other weekend. And then we'd have to sort out Christmases, summer holidays, so he'd get to see both of us then. I don't know, she won't even talk about any of that, so that's why I've brought it to court so that we can get a decision that's right for Nathan and right for me.
Is there anything else you want us to know before we hear from the respondent mother, Miss Grover? And feel free to consult with your Mackenzie friend if necessary.
No, well, I just want to say that my mum brought up me and my brother on her own. She's a good mum and she really loves Nathan. She'd never do anything to hurt him. She wants to see him almost as much as I do. I think Nathan could stay with me and my mum could see him at ours. But then Jane won't even talk about me seeing Nathan, so that's why I want the court to just to give us a decision so that me and Nathan, we know where we are. That's all I want to say, really.
Once again, thank you, Mr. Grover. We will now hear from you, Miss Grover. What would you like the court to know?
Well, what he says, Mr. Grover says, it isn't how it is. He never really took much part in bringing up our Nathan. He left it all to me. And I know he was working, but he just wasn't really all that interested. Then when he lost his job about 2 years ago, well, he just sat around and he was drinking and smoking weed. And that made him really angry. And so he was just shouting at me and at Nathan and at my mum. He was just horrible. He made everyone's life a misery.
Sorry, Miss Grover, I'm sorry to interrupt you, but I'm going to need you to speak up a bit so that we can all catch what you're saying.
Oh, sorry. Well, then on the summer bank holiday, we had a really big bus stop and he ended up pushing me and I fell and hit my head. Well, I always said I wouldn't stay with him if he ever raised a hand to me, so that was that. Me and Nathan, we went to stay with my mum and I told him he had to leave. Well, he dragged his feet over that and then after about 6 weeks, he moved out and he went to live with his mum and dad. So Nathan and I went home. Well, his mum came round a couple of days after that and we got into, well, a bit of a shouting match, really. That really upset our Nathan. She called me for all sorts, a bitch and a slag, and, well, I wasn't going to have anybody calling me that in my own home, so I called the police. She left after that. But since then, I've had nothing but abuse from Jason by texts. And I know he's been on social media. He's been out partying and smoking weed with his friends.
No, that's not right.
Mr. Grover, You must not interrupt, Miss Grover. You have been given an opportunity to put your case. And shortly you'll have a chance to respond to what Miss Grover is saying. But for now, it is Miss Grover's turn. She didn't interrupt you, so you mustn't interrupt her, please. Continue, please, Miss Grover.
Well, it was after that, when my sister showed me on Facebook that Jason was with someone, another woman. So I thought, well, I'm not having that. I'm not having our Nathan meeting up with somebody that I don't know. So I told Jason that he couldn't see him anymore, not unless he was with my mum. At least until I knew who she was. That just caused more abuse by text. But since then, he hasn't seen Nathan. I know Nathan has a right to see his father, but I just want him to be safe. And I can't be sure until I know that Jason and his mum and this woman he's been seeing, well, that they're going to treat him right.
Thank you, Miss Grover. I'm going to ask you the same question as I asked Mr. Grover. All things being equal, Nathan has the right to see both parents. So can you tell the court what sort and how much contact you would want Nathan to have with his father?
I don't mind him seeing his dad, but I have to know that he's safe. For all I know, Jason could still be off his head on drink and cannabis. And I don't want Jason coming round and giving me grief when he's coming to pick Nathan up or drop him off. Also, I don't think Nathan's old enough to stay out overnight. He's still really young, and he doesn't know Jason's new partner. Neither do I. Like I said, I don't really know.
Okay, thank you for that, Miss Grover. Mr. Grover, you now have an opportunity to respond briefly to what Miss Grover has said in court today. This is not for you to give further evidence or to ask questions of Miss Grover. It's just an opportunity for you to respond to what she said.
I just want to say that I've never raised a hand to her. And yes, I did lose my job, but I'm back to work now. I'm working for a different company. And she says that I've been taking drugs, and I haven't. No, not for a long time. Yeah, I used to smoke some weed when I was a lot younger, but I haven't touched drugs in ages. And I will take a test if she wants me to prove it. You know, we both used to enjoy a drink when we were younger, but I was never off my face with it. She was bang out of order last time my mum went round. Ms. Grover, I mean, she was shouting, swearing. You know, my mum only wanted to see Nathan. She hasn't seen him for nearly a year. I just don't see why she should be stopping my mum from seeing Nathan. And now that I'm getting my life back together and we're starting these divorce proceedings, she gets all pissed off then. And I'm sorry, Your Honour. I meant to say that she gets all riled just because I'm seeing Alison. She obviously thinks that Alison's going to be like a new mum to Nathan, but I know that Miss Grover is Nathan's mum, and I'll never do anything to change that. Oh yeah, and these text messages I'm supposed to have sent, well, you know, she gave as good as she got. We were both angry. I've still got the messages on my phone, I can prove it. So I didn't say anything bad about her. You know, we were both angry. Do you wish to see the texts?
No, that won't be necessary for now, thank you. Is there anything else you would like to tell the magistrate?
No, thanks.
Thank you, Mr. Grover. And to you too, Miss Grover. It's not easy representing yourself. So thank you for the way you have both presented your statements today. Madam Legal Advisor, is there any guidance that you have for us at this stage?
Well, ma'am, it would appear that the applicant and the respondent have very different accounts of the position they take with regard to contact with their son. At this stage, it would seem we need more information before you can make a decision. As you can see, the Cathcast safeguarding letter corroborates some of the issues that have been raised here today.
Forgive me for interrupting Madam Legal Advisor. Can I just check that both parties are aware that Cathcast is an organisation that represents children in family courts in England and independently advises the family courts about what is safe for children and in their best interests? I assume you both have a copy of the safeguarding letter from Cathcast.
Yeah, I've got one here.
Madam Legal Advisor, apologies again for interrupting you.
Not at all, ma'am. As I was saying, the safeguarding letter indicates that there is some evidence of previous drug use and of domestic abuse. Therefore, I think the court should ask for further evidence in the form of drug testing and police disclosure. You should also require statements from both parties, which needs to set out in detail the nature of the allegations of abuse. It also appears that the parties are unable to agree about contact arrangements for their son Nathan. Therefore, the statements for each party should also include details of what each party wants in terms of contact. With this information, we shall then be in a better position to resolve matters. So if I start by finding a date for the hearing, and then we can work backwards and find a date by which all evidence can be served. The earliest date I can find where there is availability is the week commencing September 27th. I don't think there is anything earlier than that. No, it doesn't seem so. Well, that may not be such a bad thing, as it will take at least 30 days for police disclosure to be returned. In the meantime, you both need to be aware that testing for cannabis needs to be undertaken by a laboratory approved by the court, and there is usually a cost to that. It's also usual where both litigants are in person that both parties share the cost. The cost for hair strand testing is £400. Can you both confirm that you are willing to share that cost?
Yes, I can sort my half of that.
I'm not sure. I'm not working at the moment, so I don't think I can afford that. I don't know. Can I pay in instalments?
I believe there is a means by which the company I will recommend to you allows a portion of the fee to be paid in instalments. I will check that and provide the information to you when the court writes to you. The alternative, I suppose, would be to ask a relative and pay them back.
Oh, I don't know. I suppose I can ask. Yeah, I'll try and sort something out.
Thank you, Miss Grover. Your worships, I think at this stage, rather than incur a further cost for alcohol testing, we should ask Mr. Grover to provide a letter from his GP to indicate if there has been any excessive use of alcohol consumption during Mr. Grover's consultations with his doctor. That will help to minimise costs and hopefully provide the court with the necessary information. Your worships, if we were to set the next hearing for Tuesday the 28th of September, that would mean that statements from the parties would need to be in the week before, that is Tuesday the 21st of September, and the police disclosure, the drug testing and the letter from Mr. Grover's GP by the 14th of September.
Mr. Grover, Miss Grover, the date for the next hearing being offered by the legal advisor is the 28th of September. Is there any reason why either of you cannot attend on that date?
No.
No.
Thank you for that. Then I am formally adjourning this hearing through to the 28th of September. You will each need to provide to the court and to each other a statement setting out your proposals for contact between Mr. Grover and his son Nathan. So the statements are not about what has happened in the past, but about what, in your opinion, is best for Nathan's future. I will say that your statement should be no more than 2 sides of A4 paper and no less than 12-point font if you word process it. The latest date for providing the statements is the 21st of September. The police disclosure will be requested by the courts, and that and the drug testing will need to be completed so that the report is with the courts by the 14th of September. Don't worry too much about these dates. They will be in the court order that will be sent out to you in a few days' time. Madam Legal Advisor, are there any other matters for the courts in this case?
No, Mama, I don't think there are. Are the applicants free to go?
Yes. Mr. Grover, Miss Grover, thank you for your attendance in court today. You are now free to leave.
Thank you.
Thank you.